You are listening to the INCJ podcast, Conversations about International Criminal Justice.
My job is just to give you a very brief welcome on behalf of the Probation Institute and International Criminal Justice. My name is Helen Schofield. I'm the Chief Executive of the Probation Institute in England and Wales. And in a moment, I'm going to hand over to Professor Nicola Carr, who's going to chair the session. But I just wanted to say that actually it's a superb privilege for us to have a webinar of this size with such a wide audience. I can see where you're all coming from on my list, and you are a very international audience today. And I think that makes the discussion all the richer. We're going to use the chat facility, as John said, for questions. So if you have comments or questions, if you would put them in the chat. If it's a question, kind of, pop a question mark at the end. I'll go through those with a bit of help from others, and we'll read those out, and Nicola will then invite responses to the questions. So we are recording, and I'm going to ask Rob Watson, who's dealing with the technical side of the recording, just to talk to us about the AI facility as well. Rob, tell us what we can also do.
Yeah, similar to the chat, you can use the AI for a recap, or if you miss it, if there's any, it won't be perfect transcription because it's a live transcription, but if there's any translation issues, if you like, or if some of the chat gets a bit garbled, then do check the AI companion. It does work quite well.
Thank you, that's great. Okay, so we're here to talk about perspectives on serious offending, and I'm delighted to ask Professor Nicola Carr at Trinity College Dublin, who is very experienced in this field, to chair our webinar. Nicola.
Thank you very much, Helen, and thank you to the Probation Institute and the International Network for Criminal Justice, who are jointly hosting and organising this event, and welcome to all participants, as Helen said, from across a range of different countries and contexts to this webinar today. My name is Nicola Carr, and I'm Professor of Social Work and Social Policy in Trinity College, and as Helen said, I'm chairing today's event. So in today's webinar, we'll hear from three eminent speakers on the topic of serious offending, who will speak to this issue from their own contexts and perspectives. Serious offending is, of course, a matter of significant public and policy concern. Where it occurs when someone is subject of ongoing interventions in the criminal justice system, for instance, under probation supervision as a serious further offence, it often raises questions about the quality of risk assessment, the appropriateness and timeliness of interventions, and whether more could be done to prevent further serious harm. Certainly in the context of England and Wales, a focus on serious further offending, or SFOs, has dominated much of the public discourse about probation services, despite the fact that SFOs are a relatively rare occurrence. However, a low likelihood, of course, does not speak to the issue of high and devastating impact on those affected. The question of how to respond to serious offending is one which services and practitioners in many contexts grapple with. And in today's webinar, we will hear from some of these different contexts and perspectives. Our first speaker, Professor Martine Herzog-Evans, who is based in the University of Reims, will present findings from a French study on risk and dangerousness in the context of domestic violence offending and how such cases are handled by prosecutors' offices. Our second speaker is Professor Faye Taxman, who's based at the Centre for Advancing Correctional Excellence in George Mason University in the United States, and she will speak about the meaning of risk and discuss her research into effective models of supervision for people assessed as high risk. And our final speaker is Martin Jones, who is the Chief Inspector of Probation in England and Wales. Martin will talk about learning from recent inspections and different approaches in the youth justice system in England and Wales, and what might be done to improve outcomes. Each speaker will speak for 15 minutes, and we will open up then for discussion. We are delighted to welcome an audience from a range of countries and different professional backgrounds. And as Helen has explained, but just as a reminder, if you want to ask a question, please do so by posing questions in the Q&A function, and we'll collate these questions and put them to the panel at the end. Without further ado, I would like to hand over to our first speaker, who is Professor Martine Herzog-Evans, to speak for approximately 15 minutes, and then we'll move on to the next speaker. So over to you, Martine. Thank you.
Thanks, Nicola, and thanks for insisting for just trying to limit to my speech to 15 minutes. I'm a chatterbox like probably most of you, so I'm sorry if I speak a little bit for too long. Please tell me. All right. So how does this work? Okay. Right. So I'll go over these things quickly because it's a large study and I'm not going to cover everything. Just wanted to say a few words nonetheless, even if it takes a minute or two, about language when it comes to domestic violence, which is what I'm going to talk about. There are a number of hashtags and names. Some of them are allegedly neutral in terms of gender. Others are feminist. There's a French legal terminology. But I prefer to use the word domestic, which I know is not used very often because being based in France, we learn Latin when we're young. And we learn in law schools about Roman law extensively, practically every semester. And we've been literally drilled how awful the dominus, the dominant male was in his household and how he had a right of, life and death over wife, children and slaves. So I think it's really the right word. Okay, but that's just me. All right, so I'll talk about a study which I have conducted. So it's not really academic, it's semi-academic and semi-practical because it was actually a prosecutor's office that asked me to conduct this study. And they had different questions. The main question was, will this particular person commit another crime, another domestic violence offense specifically, and secondarily, and that's dangerousness, it's very different from risk, isn't it? Will this person actually next time around end up killing his partner or severely injuring his partner? So I'm sort of wrapping this up in a big bundle called dangerousness. All right. And prosecutors in France are literally paranoid about this particular issue. They really want solution answers. They don't want to have their name in the local newspaper because then it goes on the internet, as you know, for life, as the prosecutor's office who let this happen. So the pressure is particularly not so much on the police in France or anybody else, or not so much on probation services. They're pretty much left alone, but it's really on the prosecutor's office. And that's sort of the flip side of the fact that they are extremely powerful. Okay. So a few words, honestly, I'm trying to be as quickly as possible. So these are a few of the danger factors that we can find in the literature, particularly these ones. We call them the flashing lights factors. But there are two literatures. It's very difficult to make sense of what is actually a danger factor. So there's a sort of a general literature on danger factors, these ones, and then you have, sorry if you can't read, folks, I can send the PowerPoint. When you read the homicide literature, you find other factors and with some multiplied risks of homicides. Some of them are similar, but others are different and more specific. Anyway, so we had to work based on these two lists. So the study was started from a question from the prosecutor's office. They were using these two devices. The first one is called, BEM, I think BEM. In English, we use the word bar. It's similar. But there's another device. So this is the bar, right? Everybody's got their own tag and system. But there's also another sort of older and less complex, both legally and technologically, which is just a phone. And you just press a button if you see the offender arriving, when there's obviously a no contact order. And the victim can call, it's actually not a private company in France. We don't like that too much. So it's state police, if they can be bothered showing up. Of course, they're overloaded as well. So a complex system. So they wanted me to, that was their question, to assess or evaluate the bar. And then we found out they were using the other device as well. So we tried to sort of fit their questions into neat research questions. And we ended up with 3 different groups. So we had the bar, or at least so we thought. We had the bar group, we had the telephone group, and there were similar offenders on all accounts. It's just for legal reasons or technical reasons that a prosecutor's office is going to choose one or the other, but it's never based on risk. Okay, so it's quite interesting because it's really the same sort of people. And then we had a treatment as usual group, which was a group of people who, for technical and legal reasons, mostly technical, could not have either one of the other two groups, the other two devices, sorry. So they were all, we checked, they were all similar. Okay, so we used file coding. They were extremely elaborate with a huge amount of details, police files, not court files, so police files, where we had all the interviews, the interviews with the offenders, with the victim, with their children, the medical assessment, the psychiatric assessment, you name it, we had it all. So it was really, really thorough. Okay, I can't obviously give you too many details. So we ended up deciding to code for a number of criminogenic needs, risk factors, danger factors. We ended up coding all of these. And whilst we were at that, we thought, well, we will also check for the two typologies that are out there, the Johnson, which is about different types of domestic violence, and the Holroyd, Monroe and Stewart, sorry for the typo there, and they typologize offenders. We interviewed victims as well, because one of the sub-question was, are victims feeling safe? Are they happy with these devices? And of course, we wanted to understand what the practitioners were doing. So we had also professional or practitioner interviews. So these were the 12 items we coded for as to danger. So we sort of merge the two literatures that I mentioned before. But we couldn't code for everything, as you will see with the results. Okay, so these are just the general questions, but as I said, it's criminogenic needs, danger, the typologies, but also whether the court were making the right decisions in allocating cases. So the thing you have to understand is that in France, the reasons why prosecutors are so powerful is because they allocate offenders into different pipes, extremely complex legal, procedurally, and on all accounts, pipes. And depending on the choice they make, the outcome is going to be greatly different. There will or will not be an option for preventive detention, or there will or not be an option for pre-trial probation, etc., etc. So they use these to sort of triage people. Okay, that's where their power comes from, really. Okay. So this is just the descriptive results. So they had usually two or nearly two concurring offences. They were very similar, the two groups. Weapons was used, as you can see, not very often, but a lot of them had weapons. So this is how many were under the influence of something. Not just alcohol, it's a rural place, by the way. There is a city where the court is, but then around it, you're immediately in this very vast and flat countryside. That's Champagne region, I can only tell you that. Okay, these are the details, unemployment, etc., the age. Very few foreigners. We can't code for second generations or third generations in France because it's illegal. We can only say they're foreigners or they're not. So, but it's a rural area, so that matches the environment. Okay, so as to the criminogenic needs, we found an average of 3 to 4 criminogenic needs in the sample, which was quite a lot, and some of them were pretty severe. I can't get into the details. So we did a versatility analysis to try and see in their criminal records how many different offences they had, which, as you know, is a sign of an lifelong or life persistent offenders and of antisocial traits as well. So that was one thing we did parallel to this, using French legal categories. And these were the sort of offences they had before. But the key thing is here. Most of them had domestic violence priors. Okay, so that's just descriptive for now. These are a few. Again, I can't give you too many details. So these were the significant ones. And the substance issue is very prevalent in this group. But then we analysed their antisocial distortions and attitudes, and we used simply Sachs and Mazza. Good old Sachs and Mazza still does the job fantastically, but also Walter's criminal thinking styles, and the two work really well. So here are our results. As you can see, some of them are very frequent, and these are just the verbalized ones, the things we that they said during the interrogations, or the, as we call them in French, the interviews, the police interviews. So they were probably thinking other things too. Obviously, we couldn't document that. So it was just a verbalized one, which is quite alarming that they could, say all these things. Right. Okay, so we coded for cluster B traits. Of course, we couldn't diagnose them. So that was a really complex part of the study. Anyway, so a lot of them had personality disorder traits at least, but that's classic. So no surprise there. And the classic trio, again, antisocial, borderline, and narcissistic. And it's exactly in the order that we can expect based on the literature. So that was quite interesting. The other ones were most of them weren't diagnosed, by the way, apart from the Korsakoff syndrome. But that's the wife that said this in this case, and a bipolar that had been diagnosed. But most of them had mental health problems that hadn't been diagnosed at all. So this one, sorry, is quite small, but it's quite a large. So we coded for coercive control. And of course, we went into all the details of what we know represents coercive control. The very surprising result was 60.7 in this case, cases of stalking, bearing in mind there is no anti-stalking law in France, which means we could only code for one particular behavior, which is sending involuntary text. And 800 texts in one day kind of behavior. But all the other forms of stalking, putting a GPS under the car, which we had cases of, but they weren't legally documented. So that's just the text or the phone calls. So you can imagine what they're actually doing. So pretty serious bunch. Right. Okay. I'm getting close to the end. Okay. So that's the antisocial continuum. So we did match the typologies. We didn't do it on purpose, but it just so happened. And when we confronted this, we crossed this with the danger factors. We did find that those who were obviously cluster B, to summarize, they were more dangerous than the other ones, which is logical as well. And there was an interesting distinction between the borderlines and the antisocial, which, I mean, it's not massive, but it's still a little bit of a difference. Our understanding is that for the court, the borderline are just, they're more theatrical, they're more visibly problematic in their behavior, their statement, etc., or they're more suicidal or whatever, whereas the antisocial are going to present probably in a more sort of adapted way. Okay, so the danger bit was really scaring as well. So we coded, remember, for 12 danger factors. So that was the average for the entire group of 102 offenders. And even the less of the less dangerous offenders still scored a quarter of all the danger items. So they were pretty dangerous, which is good. Because remember, they were triaged by the prosecutor. So this does answer their question. Are we selecting the right guys for the bar and the TGT? Well, yes, they were. Although I can't tell you what the other ones were like, because we didn't have access and we didn't have the resources. So maybe they left out a lot of them who didn't get the bar and the TGT. I can't tell you that. But at least they had an answer to their main question. Okay, so these are just slight differences. Just to give you a few examples of the danger factors, of how many, just in percentages. Again, there were quite a lot of them. Firearms, we're not the United States, but France has a lot of firearms. A huge number of firearms in the countryside. A lot of people are hunters, and it's very legal, completely accepted. A lot of them drink and hunt. That's another problem. So anyway, it's not surprising that we have this particular problem. Okay, so the problem was that we didn't have a lot of confiscation. That was the only black spot, basically dark spot, we call it in French. I can't remember the English word for it, but the area where they didn't do their job properly, the court, there were a lot of firearms or weapons that were not confiscated, even when we knew that they had firearms. Well, that was a good advice to give, or easy one to give to the court. Obviously, you should do it, but it's very complex legally, so that's why they weren't doing it. Okay, and of course, they did select, they did confiscate them more with the dangerous people. So that was a good, okay, a lot of them, but not that many breached their order. I mean, it's still a lot. So I'm making small comparisons there, but it's not a lot really, given the type of offenders we had. So that suggests that the bar and the TGD were doing a good job at containing these offenders during the orders. The problem, though, we have is that the orders are quite short. So when it ends, that's it. The victim has to give the devices back, and then she's on her own. Okay. And the good, and I think I'm going to end on a positive note, actually, on this one. The good news were 100% of the combined group, of the protected group that we called the bar and TGD, of the victims that we interviewed felt safe. So that's really interesting, because they had the device, but they were all saying, but we're afraid of what's going to happen next. And those with, the treatment as usual, conversely, who didn't have a device, didn't. Only 20% of them felt safe. So I think it's good news that this technology is satisfying for victims, and it's pretty much protects them during the order. This is a local press example of somebody with a TGD, the phone, twice. She was saved. She had her life saved thanks to the device. So the newspaper's reporting on this. Right. But the literature has already mentioned this, so it's nothing new. There's network connections, annoying battery that you have to recharge on a regular basis, problems, some sound issues a little bit, but not with TGD. Okay, so just to end, the TGD looks like it's less efficient because you still have to see the offender arriving and then make the call. But it's much easier to use than the bar from the legal viewpoint. I'm not going to give you the details because it's boring. But so a lot of prosecutors' office in France are actually using the TGD more than the bar. Far more, in fact. So this was an exception. It was a local court. There was an exception where they had more bars than TGDs for some reasons. And of course, there aren't enough. Okay, well, that's all for me. How do I unshare? Oh, there we go. Okay, sorry, that was the AI asking me questions. Thank you.
Great. Thank you, Martine, and very well to time there. Lots of interesting insights there from the French context, and I'm sure people will have questions as we come to the discussion. So thank you for that. I'm next going to hand over to Professor Faye Taxman, who is going to be talking about research into effective models of supervision. So over to you, Faye.
Thank you very much for this opportunity to share some of the research, as well as to talk about the implications for probation supervision. So I sent along, which I'm hoping will be on the Institute's website, an article that was published in Federal Probation, which is an open access journal in the United States. So anyone should be able to get access to it, about people who have violent offenses or are violent. And I've also sent along some materials about how best to think about the conditions of supervision for people who would be classified as violent. Sorry. So I want to pick up on Martin's, overview, which provided us a deep dive into some of the complex issues with domestic violence by saying, what is violence? What is dangerousness? What is serious offending? These terms are not clearly defined in the literature. They're often used differently by different purposes. And, probation departments around the world have different definitions that they use. So one thing we have to note is that there are differences in types of violent behaviors, and those differences should actually be used to think about the supervision requirements. Those differences can range from individuals who have been convicted of a violence offense. Again, what is a violence offense may be locally derived by your jurisdiction, It could be gun violence. It could be domestic violence or intimate partner violence. It could be aggression, assaults, etc. That's one type. Then there are individuals who are involved in violent behavior or the use of guns, which may be different than people who are convicted of a violent offense. Then another category are individuals who are victims of violence themselves, which predisposes that person to use violence because they've learned that technique as a way of surviving and thriving. And then we have individuals that are prone to violence due to temperament, situational factors, or prior instances. So I've just described 4 different types of people. This is not related to offense. It's actually related to behaviors. And it actually is related to 2 different ways that people can fall into an aggression or violent prone category. So one area is called reactive violence, and it has to do with effective or hostile aggression. And the other is referred to as instrumental aggression, which also is referred to as proactive and predatory aggression. This means that violence can come in many different forms, and the 2 most common are anger and aggression. Anger is much more of an emotion. Aggression is usually the behavior that's observable. So it's important for you as an organization and individuals in an organization to define what you mean by violence. It's also important to basically come to some clarity as to what you're capable of intervening with, given the cadre of services that probation agencies have. And of course, unfortunately, around the world, most often probation agencies are low resourced. So you have to really think about what it is that an officer can do. So I want to begin by looking at the probation process itself. And I'm going to start with risk assessment tools. So we all know that over the last 40 some odd years, there's been a push for every probation agency to have a standardized risk and needs assessment tools. And these tools typically measure the likelihood that someone's going to have a future interaction with the criminal legal system. And that could be for a new offense. It could be for an arrest that never results in a conviction. It could be for revocation due to noncompliance with supervision conditions. So that's one part of the instrument, which has to do with the static risk assessment or the person's history. But in that definition of static risk, we typically do not find anything that refers to violent or public safety behaviors other than the number of bites at the apple. In other words, our static risk assessment instruments aren't very helpful in defining that serious offending behavior. In the United States, for example, we typically see that people that score high risk on the many different tools that are out there in the US, they're typically people who are very low resource themselves. They're typically people who have, minor offenses. They're typically people who are unstably housed or have mental health issues. And so those individuals have a lot of interaction with the police department, but that doesn't necessarily mean that they're violent at all. It just means that they've had interactions with the police department. So, there are very, very, very few risk and needs assessment tools that have subscales that essentially help us to identify people who are prone to person-related crimes or gun violence or any of the other types of things that I've already alluded to, for identifying who might be a serious violent offender or who might have a violent prone behavior. And to be honest, even these risk assessment tools typically do not have anything to help us look at the use of lethal weapons, whether or not the person has ever been a victim of a crime or had prior gunshots, or other indications that a person had been affected by violent behavior. And the implication of that is that we're missing a lot of information about people that would lead us to see when people have much more of a tendency to want to use aggression as a way of dealing with situations in life. I also would be remiss if I did not talk about the fact that most of our current instruments do not assess adverse childhood experiences. And we know that people who have serious adverse experiences during their developmental years are more likely to use aggression, are more likely to have anger control issues, and are more likely to not be able to handle situations through communication, normal communication. And so they tend to use that aggressive behavior. So it leaves us with us basically asking the developers of these risk and needs assessment tools to really consider how best can we identify people who are violent prone or who have other aggression issues that would make us want to look at that individual differently from a supervision. Now, one thing that Martine did in her presentation is she basically illustrated a number of standardized instruments that could be used, to look at antisocial behaviors, to look at different ways that individuals manifest behaviors, but those are typically not included in the cadre of what we ask probation officers to do. And in fact, there's very little in the needs assessment part of our standardized risk and needs tools that can help us look at people who are violent or who have violent prone behaviors, which again calls for us to really want to revise these criminogenic needs to help us better identify people who not only have serious offending behavior, but also people that we want to intervene to prevent violent reactions. So our risk assessment tool is lacking typically. And that leads us to then what can officers do on supervision? So I would say the most important thing that an officer can do is to use a technique called behavioral chain analysis. And the reason this is an important technique, and this is taught as part of core correctional practices, although I have to say in most places, not enough attention is given to the developing officer skills to use the behavioral chain analysis. But the purpose of the behavioral chain analysis is to help the client to be able to look at what led them to react in the way that they did, right? So what were the precursors of that particular behavior? And what was the cost and benefits that they achieved from the reaction that they got? Now, the behavioral chain analysis really can help individuals examine what happens in their lives that makes them angry, or what happens in their lives that results in an aggressive response. And, so it's an underutilized tool. Most officers will say, well, I don't have the time to do that. But in fact, we could structure the way supervision contacts are actually dealt with in order to be able to, help the individual learn how to better regulate their own behavior. Now, we typically will talk about special treatment programs and what those programs should be. But I have to say, this is another area in which we're still trying to search for answers. We know that some of the criminal thinking errors, curriculums or strategies are very useful in helping people look at underlying motivations like revenge, greed, situational factors, territoriality. But, we have to be able to think about how these factors manifest themselves in people who are either violent prone, aggressive, or who are engaged in behaviors that could present physical harms to others. So and again, many of the criminal thinking error curriculums do not essentially address these violence issues. And I'm sad to say they also don't typically address trauma or some of the mental health conditions like depression and anxiety that individuals have that might influence their behaviors. So we're kind of stuck with asking the question, so what can we do? What are some of our choices here that we could actually think about? In the United States, up until about 4 months ago, because we've had a major change in the way business is being conducted, which I'm sure many of you have heard about. But we were developing something called violence interrupters. And those violence interrupters were people with prior experience on supervision or people who had prior involvement in violent behaviors. And we would couple these violent interrupters with individuals on supervision to really help them identify what the behaviors are and to help them really think about what their alternative response is. So the violence interrupters are really designed to be like a form of peer supports, but they're people who have overcome their prior behaviors. And therefore, there's the potential for those violent interrupters to become role models for individuals. And there are also the potential for really helping someone to see that it is possible to change your behavior. Now, a major part of supervision is the conditions that are assigned to supervision. And I do want to bring up, So I'm going to share with you, and I gave this information to the Institute, but we have on our website for my center something called the appropriateness statements, which provides practice guidelines for community supervision. And you can go onto our website and download many of different topic areas like contacts or motivational techniques. And what we've actually done is you can look at these techniques and look at what are the strategies that are useful. And then you can also look at whether or not the strategies are useful for different types of clients. So I encourage people to just go to our website and navigate through here because we really focused a lot of attention on this question. What are special considerations for subpopulations? And we broke it down to different types of violent behavior, gang-involved violent behavior, general violence, intimate partner violence, serious mental illness, and even violence associated with substance use disorders. And we're able to go into difficult topics about different types of conditions of supervision and what would work best based on what we know in the research literature, because all of this comes from the research literature, but what we know that works best with a particular individual. So, I encourage you to explore. If you have any questions, you can contact us by email. This is meant for, officers to use to really kind of think about how it is that they should be assigning conditions for what kind of type of people. Of course, one of the things we want to stress is that it is better to have fewer conditions that are focused on the behaviors of a particular individual than to have too many conditions. And I say that only because in the US, we love to give too many conditions. I mean, the average person on our supervision has 17 conditions, which I have to admit, I could not manage myself. And so, really thinking about time, what conditions you have for a particular individual is really important, because sometimes when you overload people actually do worse. And, that's one of the things we want to avoid. So I want to conclude by saying probably the most important thing we've learned is how important the working relationship is between an officer and the person they're supervising. And this working alliance has been really instrumental in helping to reduce negative outcomes. But we also found that when there is this poor working relationship, it can actually counter effect by, actually inciting people to do more of the behaviors that we don't desire for them to do. So the key component here is part of what's called procedural justice, which is you need to build trust. You need to give the person a voice. This is where the behavioral chain analysis is very useful. You need to have processes and procedures that are transparent enough so people know when they're doing well on supervision and know when they're not doing well. And you need to make sure that the person who's on supervision feels comfortable with the officers that are supervising them. That leads us to an important part of working alliance, which is to use incentives instead of sanctions as a way of helping people to redefine their behavior. And incentives, has basically been shown to be a very effective tool. They're very hard to implement because we all sort of share an attitude that adults know what they're supposed to do. But everything we know about developmental issues, how trauma affects individuals, how people's prior past experiences affect their behaviors, everything we know is that individuals need to be incentivized as a way of helping them relearn how to react to situations in life. So there's a literature out there called contingency management. We actually have in our appropriateness statements, information on incentives and contingency management. So I think I am at the end of my time here. And I appreciate the time of sharing this information, and I'm happy to answer any questions. And thank you very much for this opportunity.
Thank you very much, Faye, for that really masterful overview of a wide body of literature and really, really interesting points that you made. And I'm sure people will have questions to ask when we come to the discussion. So now over to our final speaker, Martin Jones, Chief Inspector of Probation. Martin, over to you for 50 minutes and then we'll come to the discussion. Thanks.
Thank you, Nicola. First of all, I just wanted to say how grateful I am for the invitation from the Probation Institute to speak at this international seminar. And it's an absolute pleasure to follow Martine and Faye, who've given their international perspective. And I hope that my talk doesn't pale by comparison with their sort of expert view of what they've seen. Now, I was appointed Chief Inspector of Probation in the spring of last year. But I also describe myself as something of a dinosaur because I've been around the justice system for over 30 years now. I've spent time working in the world of parole as the Chief Executive of the Parole Board for England and Wales. Also spent some time working in the criminal courts as well. So I am very aware of the issues that arise around serious offending. I will talk to you about what we have learned from serious further offences through the lens of our inspection activity. And it would be helpful perhaps to start by talking about what the role of inspection is. Our vision at the Inspectorate of Probation is to drive high quality probation and youth justice services that change people's lives for the better. And as the independent inspection regime, we look at both probation and youth justice services and set the standards that shine a light on the quality and impact of those services. And of course, what we want to drive is system change, better outcomes for individuals and communities. Just in terms of the headlines, particularly for the international audience, people from England and Wales will know some of these numbers. It's important to be clear on the job that the probation service currently carries in England and Wales. Our probation service is carrying a caseload of nearly 250,000 cases. So there's been a huge amount of concern about the size of the prison population in England and Wales. The probation service is dealing with nearly 3 times as many people. Now, given the scale of that work, risk cannot be eradicated. People are being released from prison. They are serving community sentences. They are directly in contact with the public. But we do, of course, owe it to victims, the public, and the service itself to seek to learn lessons where there has been a serious further offence and to be transparent about this. In my long experience, it is very rare indeed for an SFO to be the fault of a single individual or a single mistake. SFOs, in my experience, will often occur because of a combination of events, decisions, sometimes chance events. They will often involve a range of agencies. And I was very taken in listening to Martine and Faye about the importance of other agencies. They talked about police officers, prosecutors as well. And I think it's important that we take account of the fact that the probation service is not carrying this risk on its own. However, through my lens of day-to-day inspection, I routinely find issues with the quality of work taking place on the front line of probation. My general summary at the moment of what is happening on our probation frontline is it's a service under huge pressure with too few staff, with too little experience managing too many cases. And of course, that impacts on the quality of work that's then taking place on the front line. It is therefore unsurprising that in most cases where there has been a serious further offence, there is learning to be identified. Although I have to say it is hard to say with certainty if the SFO itself was preventable. So just to give you some background on the SFO process. Now, a serious further offence in England and Wales is a defined thing. So these are the most serious sexual or violent offences committed. Now, that process kicks off when somebody is charged and appears in court for a qualifying offence, which was alleged to have been committed whilst that person was under the supervision of the probation service or within 28 days of that supervision terminating. And an SFO is then reviewed, commissioned locally by the local probation area, who do an internal piece of work to understand what has happened. And the intention is that that document then should be shared with the victim or their family so they have an understanding of what may have gone wrong. It's also there to provide a robust and transparent analysis of practice, and it should be written in a way which is accessible to both audiences. So each probation region in England and Wales has an established SFO team consisting of reviewing managers and other people that look to examine and draw out those lessons. And the inspectorate then undertake a review of 20% of those to ensure that those are of the right quality. Now, when I say it earlier that the probation service is dealing with nearly 250,000 cases, and we talk about risk to the public, I think it's really important not to be alarmist about this. SFOs, fortunately, are very rare. We see consistently over the last decade or so around 300 proven serious further offences in England and Wales. More people than that are charged with offences because some are acquitted during the trial process. And the SFO process is triggered at the point of charge, so you get more reviews compared to the number of proven SFOs. But I do think it's important to take a step back, as our earlier speakers say, and also think about the fact that actually, if you're not the victim of the most serious offence, you're still suffering consequences that may last with you for some time, and particularly if you're a victim of domestic abuse. Some, of course, will be offences of violence, which may not qualify as the most serious, but it still has a lifelong impact for people. So our role at the Inspectorate is to provide quality assurance of the SFO reviews against an agreed set of published standards. We offer benchmarking events to ensure that reviews are undertaken consistently. We will pull together multi-agency learning panels to seek to identify what lessons there are across the system. We publish an annual report with our findings, and we are also from time to time asked to provide an independent review of the most serious further offences, which go right to the heart of confidence in our criminal justice system and indeed the probation service. Our last report found that 46% of the SFO reviews that we considered were defined as good, with 52% requiring improvement. So again, there's an opportunity there not to ensure that you learn the full lessons. We would want to ensure that we're learning as many lessons as we can. Some of that is also about the clarity of information for victims as well. There is some variation amongst probation regions. I would say that some of the quality of that is driven by the pressures on those teams, which are significantly overstretched. And if you're a local probation leader, you've got to make a choice in relation to where do you put your resources? Do you put it on the front line to deliver better probation work with those people that you're managing, or do you put it on reviewing? So that is a pressure that certainly the service is facing. And I understand that pressure, otherwise, of course, we need to ensure that there is learning. So what are the themes that arise when we look at our SFO reviews? I think it would be fair to say, when you speak to staff at the front line, that there is a perception of blame around SFO reviews, a feeling that we are seeking to identify individual failure. It certainly causes stress and anxiety, particularly for newly qualified officers who may have only qualified in the last few years and suddenly something terrible happens, even if it's rare. The role of SFO reviews is absolutely key to the process, to take a look at the evidence of what is happening, to understand what the keys and what the triggers are, perhaps, for something going wrong. I also think there is a need for a recognition of the organisational context in reviews. At the moment, in some probation areas, we are seeing staffing gaps in the order of about a third, and in some areas as much as a half of probation officer vacancy. So clearly that's going to impact upon the quality of work undertaken by people in the probation service, but also around the amount of time you have to identify where things may be going wrong. So there's an increased risk of things perhaps slipping through the cracks. Some people, of course, have more positive experience of SFO reviews and see it as an opportunity to learn lessons. I would also say that providing clear and timely feedback to victims is absolutely vital, and it needs to be an area of constant focus to ensure that we give them the information that they need. Last year, in our annual report, we surveyed staff, and I'll just give you a quote of what one member of staff said. This member of staff said they feel targeted by the SFO process. They feel it's shrouded in secrecy. They're not privy to the final reports or the submissions. They're not privy as to whether organisational or systemic issues are being addressed. They receive an action plan for themselves, and that's fine, but it does leave them wondering what other issues they may have been raised. Are those explored, and if so, how? We need to be sure of whole system approach to SFO learning. And I think that's important for us to listen to ensure that we learn lessons throughout the system rather than look at individuals. Certainly from our looking at frontline practice, many of the issues that we see in SFOs are repeated in other cases. There's almost an element of chance here. When things go wrong, it's almost because the fates align on a particular day rather than that an individual probation officer could have stopped something dreadful happening. We also undertook a survey of staff in the probation service. They highlighted worries around support from their management around SFO reviews. 23% of staff thought there were sufficient opportunities to learn from reviews. And I go back to this point about learning. If something dreadful has happened, the organisation needs to learn from that. And sometimes, for me, the learning is simply follow the best practice, follow the good practice, a probation practice, and actually we'd have a more robust, sensible, defensible set of decisions. And that's, for me, what it is. You cannot eradicate risk. It's about ensuring you're making defensible decisions in the light of the evidence that you know. Around 40% of respondents said they were more confident that they had changed their professional practice in line with the findings from the review. Now, in our reviews, we also identified problems, which again, Martine and Faye have talked about in terms of risk assessments. And again, for us, this is around ensuring that the right information is collected. Quite often the information is dependent upon what the probation service has. Have checks been made with the police and with other local authorities to ensure you understand the risk that those people may pose to the community? And sometimes the risk perhaps was too narrow, not looking beyond the needs of the individual case, and in particular around domestic abuse, understanding risks to future partners, and identifying what the triggers would be. What are the triggers that would mean this person would move from a position where their risk is manageable in the community to somebody that may need further assistance and further help? We also saw issues with inexperienced officers completing risk assessments and a lack of training. There has been a huge problem in recent years with the loss of experienced probation officers. And indeed, in some offices, you have very few experienced probation officers to sort of provide some of that coaching and mentoring that people need. We need a stabilisation of the service to ensure that they can learn from this in the future. We also sometimes found that information was taken at face value. So probation officers sometimes listening to what an offender is telling them, but actually not then checking that with other sources and verifying that. And one of the things that, for example, we've highlighted from experienced officers, actually the importance of a home visit to understand exactly what the home circumstances are of somebody, particularly around domestic abuse. Other issues, risk not being reviewed when new information about risk comes to light. Again, for me, this is about constantly asking yourself, I've got new information from having spoken to that individual, new information from the police about charges. What does that mean for my practice? What does it mean in terms of managing that individual? Excessive workload certainly having an impact on the quality of assessments, and insufficient multi-agency working. The one thing that I see, I think, through all of the serious further offences that we've seen recently is that better joined up working between prisons, probation, police would keep the public safer. And I think that has to be the aspiration, particularly on higher risk individuals. And finally, there's a point for me around ensuring victims get what they need. In my former role as chief executive of the parole board, and in my time since becoming chief inspector of probation, I've met a number of victims, and they speak with incredible dignity and courage, I think, about their experience of the system, because quite often, people are faced with something that comes out of nowhere, and suddenly they're the victim of a very serious offence. We should do all we can to provide victims with a clear and understandable picture of what has happened and why. That may give them the answer to some really important questions. And I'm increasingly interested in how this can be improved. Can we identify best practice in relation to providing that feedback for victims, but also for the individual officers as well? So my final reflections, I think I've got 2 minutes left. The reason I'm Chief Inspector of Probation is because I think effective probation supervision has genuinely transformative potential to change lives. Probation, when it is done well, turns offenders' lives around, keeps the public safer, reduces future crime and future victims. It also, helpfully, should keep some people out of prison. However, if it is to succeed, it must be properly resourced, and it must have the levers it needs to make a difference. We know that housing, addiction, mental health support are huge drivers behind offending, and in particular serious offending. And we also need to see there is no tension between public protection and assistance. They are two sides of the same coin. If we can get the basics right, we will make a difference. We cannot stop crime happening, but we can ensure people are kept safer. Good assessment, the right interventions at the right time, the right controls where they're necessary, and the right support, we can make a difference. Thank you very much, and I look forward to the discussion.
Thank you very much, Martin, and really interesting oversight of some of the findings from the SFO review process and HMIP's review of the whole system. We have a number of questions coming through in the chat. I know, Helen, you've been keeping an eye on those. I've seen them come in as well. So perhaps I just start by picking those up, the ones that are coming in. Just to start there, there's two relating to SFOs. The first one from Osman Nazir, who says he agrees with the whole system approach to SFO learning. Happy to say this is something all SFO reviewers have to input into when undertaking their reviews. I guess the question mark is, how do we hold or account or push for more with some of our statutory partners in probation? So just the context there, I'm sure you can explain it better than I can, Martin, but the SFO review process tends to look at the probation side of practice, but obviously there may be other agencies and so forth. So how does that input get brought into the system? And
Nicola, I cannot overemphasize how important this is. And in all of the SFO reviews that I've seen over the last 20 years or so, there has been information somewhere in the system that would have assisted the individual probation officer in managing that risk. First of all, in understanding the risk that individual poses, but then second of all, when that risk is inevitably in the community, we need to be realistic. You can't keep everybody in prison. 99%, well over 99% of people in prison are going to come out at some point. They need to be managed. They need to be supported in the community. We do have in England and Wales effective multi-agency public protection arrangements, which can be effective. The question really is, how do we ensure that's mainstream so there is information sharing as a matter of routine to ensure that we keep people safe, but also that we pass on information. I was speaking yesterday in Parliament about the experience of people on probation with autism, and actually some of the problems there was around sort of adequate information sharing between partners as part of it. I mean, we need to see how we can use technology with appropriate safeguards to ensure that information follows people, to ensure that we keep people safe, whether they're on probation or they're in the community. I think it's incredibly important. But I certainly think, and I would contrast it perhaps with the youth justice system, where we tend to see much better performance because there are very strong statutory levers to ensure that you pull in the police, local authorities and other people around the table to ensure they play their part in reducing youth offending. What you've seen over the last 15 years is over a 90% reduction in the number of children in custody. So you do wonder whether there is more that could be done with the statutory underpinning to ensure that there are the correct local partnerships in place to reduce general reoffending, but in particular the most serious harm. And particularly, I mean, we've got a government that has a mission to reduce violence against women and girls. The only way you're going to achieve that is by ensuring local partner agencies work together to address that.
Great, thank you. I should also note, I suppose, with the comparison with youth justice, the much lower caseloads that they have also, I think, is relevant. So there's some other questions with SFOs, but I'm keen to bring, and we'll come back to them, but I'm just keen to bring others in. So Martine, there was a question earlier on about any observations around military veterans and violence that can be shared. Maybe I'll ask you first, Martine, and then Faye, if you have any kind of observations from your work. Has it come up as an issue, Martine, in the work that you've looked at?
Not at all for me, no.
Okay, all right, okay. Faye?
Well, there are in the United States a number of issues now trying to set up specialized caseloads for people who are veterans or military experiences. We've even, we have specialized court systems called problem-solving courts, which essentially bring people into contact with the courts on a much more frequent basis. And there's a number of veterans courts that have actually been set up. And we did have, the status is currently unclear, but the Veterans Administration, which is responsible for the medical and health care of veterans in the United States, they actually set up what's called Veterans Justice Officials, VJOs, that basically were to help people who are veterans who get involved in the legal system to access different types of mental health, substance use, and trauma-based services. The status of those VJOs is unclear right now, but they were known to, they're like the violence interrupters. They're people who have a good touch to the clientele and are usually much more respected. But essentially, a lot of probation systems do not screen for whether or not someone is a veteran in the past. And these initiatives really are coming out of more the Veterans Administration, which realizes that almost 20 or more % of veterans end up involved in the criminal legal system after they come back. So
yeah. I think, thank you for that, Faye. It's really interesting to hear the practice in the States, although, as you mentioned, slightly uncertain about what's happening with that. There has been a focus on this in England and Wales, and Helen is pointing to that. Research commissioned by the Probation Institute, Helen, if I'm correct, looking at this particular issue in England and Wales, that's available on the Probation Institute website. And that particular research, conducted by PI and Liverpool John Moores University, looked at some of the kind of risk factors around people with military history and commission of serious offences. So those kind of connections certainly have been made in England and Wales also, and there's literature on that. Martine, one of the things that you talked about in your research, which was interesting, was this role of the prosecutor. And it's interesting where the kind of decision-making and hence the responsibility sometimes lies in the criminal justice system. I was interested in the extent to which prosecutors are gain specific education about domestic violence or intimate partner violence that might inform their decision-making. You know, are they aware of these particular risk factors that you identified in your research? And does that inform what they're doing, or how does that work in practice?
Well, things are changing really rapidly at the moment in France because the Me Too movement has really shaken the country. And also we've had a few high profile cases, and not necessarily actually in domestic violence, but I mean, in domestic violence, we've got a Counting the Dead movement going on, but also in high profile sexual cases, sexual offender cases like the Pellico case. I'm sure you've all heard of it. And it's really, really shaken the country. I mean, I remember a few years back, prosecutors would say things like, in court, I don't understand. You've been battered. What are you still doing with this guy? And this doesn't make any sense. And therefore, I'd suspect that you're not telling the truth, you know, and it's sort of classic things. And that's quite recent. But things are really changing. So they're receiving a lot of training, because the one good thing in France is that we've got a judiciary academy. So you can't be a judge without receiving 2-year training, which is amazing. And then they have continuous learning, which is also mandatory. So, and they get a lot of training in domestic violence and a lot of other things. And gradually, a lot of it is criminology / psychology / social, you name it. And so the prison academy, the judiciary academy is doing a really good job. So I can see things changing. If you follow them on LinkedIn, there are a lot of prosecutors there, and a lot of them are becoming really aware of coercive control and the DARVO techniques and all of that, where maybe 2 years ago they'd never heard of it. So I'm quite optimistic because it's rapidly changing. Yeah, okay, but so the training they get is really legal, the one I'm talking about, but the continuous learning is more than just law. And that's where they're learning a lot of interesting things. So yeah, it will gradually get much better, I think.
Great, thank you. There's a question here from Steve Collett. Hello, Steve. Martin, you were recently interviewed by Radio 4 and spoke eloquently and forcefully about probation's role in reducing the prison population and protecting the public. However, you were introduced as the head of probation. Wouldn't probation's role and credibility in dealing with serious offending be aided by the probation service leadership speaking up for itself, i.e. being taken out of the civil service and returned to structures of local accountability? That's an essay question.
Well, yeah. Thank you very much for those kind words, Stephen, about my performance on Radio 4. It's always a challenge trying to sort of carry your message in that way. I'm quite deliberately, I have to say, doing media to talk about the work of probation based on the fact that I do think we need to tell the story about the challenges probation faces, but also the important job that they do. I'm a firm believer that you need to step into that space and speak directly to journalists and to the public about it. So certainly my time in charge of the parole board shows that there's no use just ducking and acting like a tortoise on these things. You've got to engage in the debate and explain the reality of it. I've got to say, I don't believe, and obviously I've been a civil servant, public servant for some time now, I'm not so sure that actually it's the civil service that prevents people from doing that. I think with the will the probation service should be able to speak up for itself and to ensure that it can explain things. Of course, it needs to avoid the politics sitting around some of these questions, but I think the probation service can speak up maybe a little bit more and a bit more confidently about the difficult job that they are doing, and to face up some of that. Certainly, that was my experience at the parole board. Was it's worth sometimes engaging in the debate appropriately, but if not, I'm certainly happy. But as you say, I occasionally I need to correct people who think that I'm in charge of the probation service rather than the chief inspector who's there explaining what is currently good, and also sadly sometimes what is not working as well as it should.
Great. Thanks, Martin. And I see, Faye, you put a link in the chat to the specialised work with veterans, which is really helpful. Thank you. Helen had asked a question in the chat, but I think it'd be interesting just to hear a little bit more, if that's okay, Faye, about how the individual is engaged in the behaviour chain analysis. How is that behaviour reported, and what's the type of work that's done with individuals?
Well, essentially, the behavioral chain analysis involves a discussion with the client, and there's a particular, usually a worksheet that the officer and the client can work on together that helps drive the questions about, what were you thinking about before you committed whatever crime that person did? Were you angry? And therefore uses that probation contact time to really help the person fill out their worksheet. That's usually session 1. Session 2 is the next contact coming out back and saying, okay, what other options could the person use? Should they have, encounter similar situations? So usually it's restructuring the contact time so that you're making different use of that contact time, and then revisiting the behavioral chain analysis over time. I can, let me see if I can quickly find a copy of that tool to put in the chat box for everyone. But okay. It's really just another strategy for changing the face-to-face contact with an individual.
Yeah. So it sounds like it's kind of based on cognitive behavioral type principles.
It is. Yeah. It's a variation of CBT involved in core correctional practices. Yeah.
And just on the point, like you were talking quite a bit in your presentation, Faye, about basically the inadequacies of current risk assessment tools for capturing, particularly around violent behaviour in that sense. You were referring a lot to static risk assessment tools, if I understood you correctly. Do you not see any of those kind of newer fourth generation or whatever dynamic tools as being able to capture, or have you seen any examples of assessment tools that had a better kind of accuracy or sensitivity to violence in particular in your practice at all?
Essentially, most of the risk assessment tools that exist aren't very creative and don't necessarily revise the formula. The one exception is a researcher, Zach Hamilton, who's at the University of Nebraska, and he has developed a new instrument that really looks at different violent prone behaviors. He just recently published some material on that, and I can put that in the chat box. But what's exciting about Zach's work is that he has challenged sort of the way in which we've thought about risk and needs. Most of the times in the instruments that are out there, they look at, did a person ever do this, right? So, and guess what? What you do at 15 doesn't necessarily mean what you're going to do at 30 years old or 40 years old. And so he's refined the questions to really look at contemporary behavior and been able to really come up with some new ways of thinking about someone's criminogenic needs. It's come up with, in the health industry, it's called the GAF score, which basically is severity of health problem. Well, he's come up with a GAF score on criminal needs. But I'll put that information in there. I would basically say that we need much more attention on violent and serious behaviors to differentiate people who basically either have aggressive tendencies or who really don't control their emotions, their anger. As we all probably know, anger, our anger management classes around the world are fairly pathetic. They don't really challenge people to really kind of develop alternative responses. And so this is another challenge that we have is, we really need to think more clearly about, what it is we really want to change. And, as Martin indicated here, in his discussion of the UK, changing these serious behaviors requires the organizations to make choices. They're going to spend time on that or the 200 people on supervision. I personally think that we need probation systems that do a lot of triage. When we know we have violent prone people, they should move into a category and we should deal with them. When we know we have substance use people, let's put them into a different category where we have, officers who know how to deal with those behaviors. And we don't have a system that does that type of triaging, and none that I'm aware of around the world. And if I'm wrong, I would love for someone to tell me about their system.
Okay, well, there's an invite if anybody has any experience of probation triage around this particular issue. It'd be great to know and put it in the chat. Martine, just go back to Martine had put a question in the chat earlier for Martin. Have you found whether some of the mistakes made are more frequent when some of the victims, for example, in femicide cases in particular, belong to minority groups? Based on Martine, do you want to? Sorry, I'm ventriloquizing here. You could ask the question yourself. They're based on contacts with French prosecutors. This has come up in your work.
Yeah, I mean, it's just because I'm very regularly contacted by prosecutors who just had a horrible case and they're like this. So I do a lot of fear containment, etc., and then taking a step back and retracing their steps to see what happened. And Martin is actually right. They usually have a number of factors. But when I ask what the victim name was, they very often come up with a foreign name. And I'm starting to see a pattern. Of course, I haven't got any research to back it up. We don't have the equivalent of what Martin does. We don't have these inspection services. I mean, they do exist, but it's just for very serious cases and on an ad hoc basis. So it's not a regular thing. So we don't have the stats, but I would be really curious to know if that's been sort of looked into, because yeah, again, I'm seeing a pattern, but I may be wrong. It might be sheer accident. One can be positive.
Happy to have a go at that, Nicola, if that's helpful. I mean, I've got to say, Martine, I completely agree with you. That would be my experience. Is generally speaking, people that are at the margins of society and have vulnerabilities tend to be more likely to experience the more serious. And again, my understanding, again, from the data, I don't pretend to be an expert on this, is generally speaking, people tend to be, if they experience domestic abuse, tend to experience more serious domestic abuse, whether you've been previously been a victim or you're from a minority group. And I think some of that is around almost you don't have the support system, you don't know how to almost engage with the state to get the protection perhaps that you need as part of it. The one question I have, so we do publish some pretty comprehensive statistics on serious further offences in the UK. I'm not sure I've seen it broken down by diversity characteristics, actually. It might be something that maybe the Ministry of Justice can look at to understand what those trends are, given the fact that over time, each year they're collecting data on about 600 people being charged with serious further offences. It would be interesting to look at the sort of typography of the victims of those cases. But I would certainly agree that's what I tend to see from my experience.
So the point I was trying to make was not so much that there were more cases where the victim was a foreign origin, but it was more the case that the police was dismissing or not treating these cases seriously. The victim would show up and say, "I've been battered." Yeah. And, and they weren't taken as seriously. I mean, again, it could be an impression and maybe it's just complete coincidence, but practically every time these cases were dismissed by the police or the prosecutor's office or the person who takes the phone when they receive the information from the police. And my impression is that they get dismissed more, but I may be wrong, but I think it needs investigated.
Martine, actually, sorry, I've answered this completely incorrectly then, because I'm looking at it from the perspective of probation, whereas your question is from the perspective of the police and prosecution. I've got to say, I think there is wider work undertaken by the Inspectorate of Constabulary for England and Wales that has looked at precisely that issue, and they certainly have found that there are issues in relation to how seriously some police forces have taken that. So maybe we can share that with you in relation to what the evidence
be interested. Yeah.
Right, we have a question from user's iPhone, not real name. Martin, having listened to Faye Taxman, do you have a view on the exponential rise in conditions in England and Wales and the relationships to recall and what they say about the supervisory relationship and an officer's understanding of their client? So has there been
what a fantastic question from user's iPhone. Thank you so much. I think it's a really, really good question. I think we've seen a very similar exponential growth in licence conditions in England and Wales. And again, some people will be aware of this. I mean, the recall population in England and Wales has increased. When I joined the civil service in 1993 as a man with much more hair and much less wrinkles than I had now, the recall population in England and Wales was fewer than 100 people. Today, it's over 13,000. It's an extraordinary increase. And some of that is driven, I think, by fear of SFOs, but some of it is also driven, I think, around two other factors, which I think the people need to look at. One is the number of conditions. So therefore, it's almost inevitable, if you've got chaotic people that are engaged in the system and then you give them, 15, 20 conditions that they apply, it's inevitable they're going to trip over their own feet pretty quickly with a chaotic lifestyle and start getting into issues around compliance. Now, of course, recall should be about risk, but sometimes I think those things can get confused from time to time. The final bit, which I've seen certainly over the last 10 years or so, I've described our probation service being under huge pressure and facing, too big a caseload versus resources they have. I also think what you've seen is less support being available in the community. And I think the probation service at its best, when I see it out there, are people that are working with somebody, developing that positive relationship, so that when something is going wrong, they're able to make an intervention. I think we described it, as helping them. That's the point for me, is there's a problem. How do you help them with the problem? If you can help them with the problem they're encountering, maybe it's housing, maybe it's a fallout they've had with their neighbour, you can always prevent things going wrong. But if it escalates to the point where it's then coming out as being arrested by the police for some sort of disturbance, then recall to custody is that. And I think it's something which probably, if you could get the probation service to be able to move back to some of its basic stuff, I think you'd have a lower recall population, you'd have better compliance and better trust between probation officers and people on probation. But you need to sort of work through that area. But I think unnecessary, over-restrictive license conditions, which may be disproportionate to the risk, may be one of the reasons why the recall population has increased so markedly over the last 30 years.
Thank you for that. And just one final question. So we hear user's iPhone was also known as Joe Thompson. So thank you for that question. So just one final question. I might ask you to reflect on a comment question that Lorraine Gelstorp has made. Just ask you all for a quick reflection before we wrap up. So Lorraine has said there's usually a story of complexity behind serious further offending, drug, alcohol misuse, homelessness, broken relationships, etc. How best can we address what victims need and challenge populist punitiveness at the same time? And maybe if I'll ask you to answer that first, Faye, and then come to Martine, and then Martin, and then we'll finish.
Are you asking the question, like, what is the order by which we should intervene with people if they have complex needs, multiple? Is that the question? I'm sorry, I was...
It's okay.
The behavior chain analysis.
Yeah. So the question as put is, there's usually a complexity behind serious further offending. lots of, and you've surfaced that in your work, and Martine has referenced it, and Martin, drug, alcohol misuse, homelessness, broken relationships. How best can we address what victims need and challenge populist punitiveness at the same time?
So I would basically say, trying to address all of those factors at once is usually detrimental to the individual. One, because as a probation officer, they're not trained as clinicians, one. And two, it gets very complex. So, essentially, housing stability is probably the first thing, because if a person does not have a stable place to lay their head or to live, their life is kind of juggling all these things to get food and to get, shelter and everything like that. So, we try to focus on housing first, and then mental health and substance use, because, if people are experiencing, addiction, or they're having some mental health crisis, that means that they can't focus their attention on other factors, because they're getting cues in their brains that basically are saying, do this, do that, and they can't manage that. So, helping people to stabilize their mental health, substance use conditions would be number two, after the housing. Then I think, looking at positives in a person's life. Do they have an employment history? Do they have family that can support them? And bringing those positives in. So, I think we have to be a little judicious in terms of what we can accomplish. And I think getting people to be somewhat stable in their environments is probably number one. Mm-hmm. And I just put the behavioral chain analysis in the chat box too.
Fantastic. Thank you for that. So come to you. I think, Lorraine, maybe your question is getting at that tension of meeting offenders' needs and how we do that and still maintain a focus on, kind of a desire to address victims, this kind of dichotomization. Maybe I'm interpreting you wrong there, Lorraine. Is that what you were getting at?
No, I think you've captured that very well. I mean, elements of the criminal justice system keep saying we need to protect the public, and that takes us down a populist punitiveness route, whereas the evidence points to needs of both offenders and victims.
Yeah, absolutely. Thank you. So thanks, Faye. You really addressed that in your response. Come to you, Martine, and then we'll finish up Martin. That's okay.
Gosh, I mean, Lorraine, isn't that a complicated question for the interval session? I don't even know where to start. I would say time, resources, adequate training. I think somebody said, I think it was Faye, that probation officers aren't clinically trained. How about we change that too? I think it was Teresa Gannon that published a paper in 2019. I cite it all the time. That's why I remember the date. It says, where have all the psychologists gone? So it focused on psychologists, but I think for me, the key message was that nobody's really trained with the depth that is required for the extreme complexity of what they're supposed to do. And so I think, and also I teach at university, so these are questions that I constantly have on my mind. What kind of skills do my students need, and does the field need? And it's a constant, with my colleagues, we constantly ask this. So not doing everything at the same time, but having breadth and depth in what we do. And the risk assessment tools, I agree with Faye, I call them, I tell my students, it was worse when we didn't have them, and I've seen it, right? It was abominable what was done before. But, so, okay, we now have the tools, but it's still basic. it's still crude. And we need to work forensically and go deep and deep and deep and deep into the problems. And so we need time and resources. And so we're back to the question of who do we include in the criminal justice system? We can't deal with a cat making too much noise at night in the criminal justice system. I'm not even joking. And at the same time dealing with these very serious cases, we've got to make choices. And maybe somebody else has got to deal with the cat. Maybe we need other institutions, the community, whatever. But criminal justice system can't deal with everything. And there are some serious systemic questions that we've got to ask. Training and allocation and whatever. So yeah, I'll shut up because otherwise I could go on for ages.
Thank you, Martine. And Martin, a one-liner?
I completely concur with what has already been said. I guess the final point for me is if the starting point is understanding what the needs of the person that you're working with, that's a pretty good starting point. Because of course, if you address that, homelessness, drug addiction, and other things, there's a chance actually you will prevent some serious further offences, which will come in a small percentage of cases. The more you can focus on what the needs are, the better. But you need to ensure you understand who you've got in front of you. Is it a risk that they may go shoplifting, or is it a risk that they may commit a serious sexual or violent offence? I think understanding that distinction is helpful, but the starting point has to be how do we support that person to be on the right path. Thank you.
Great. So thank you all very much. Helen, I don't know if you want to say a final goodbye on behalf of the Probation Institute.
Yes, I'd love to, very quickly. Goodbye and thank you, really. What's been so fascinating is that we started out with 3 perspectives, using different language and tackling these issues from different places. And as we've talked on, our conversation has come closer and closer together. And that I suspect we could talk all evening, actually. So I want to thank everybody who's joined, the speakers particularly, and those people who asked some really, really helpful questions. It's great. Let's do it again sometime. Thank you. Thank you very much.
Thank you, everybody.
Excellent sharing.
Thank you.
Thank you, everyone.
You have been listening to the INCJ podcast, Conversations about International Criminal Justice. To find out more, go to our website at criminaljusticenetwork.net or follow us on Twitter at INTCJ Network.